You would then answer yes to the special verdict question. In order to answer no, you must unanimously agree that no is the correct answer. If after full and careful consideration of the evidence you are not in agreement as to the answer, then do not fill in the blank for that question. For the aggravating circumstance to apply, the defendant must have been a major participant in acts causing the death of Wayne, Judy, Scott, Eric, Olivia, and Nathan Anderson, and the aggravating factors must specifically apply to the defendant's actions. The state has the burden of proving this beyond reasonable doubt. If you have a reasonable doubt whether the defendant was a major participant, you should answer the special verdict no. 30. If you find the defendant guilty of premeditated murder in the first degree on any of counts 4, 5, or 6, you must then determine whether the following aggravating circumstance exists. The defendant committed the murder to conceal the commission of a crime or to protect or conceal the identity of any person committing the crime. The state has the burden of proving the existence of any aggravating circumstance beyond a reasonable doubt. In order for you to find that there is an aggravating circumstance in this case, you must unanimously agree that the aggravating circumstance has been proved beyond a reasonable doubt. If you unanimously agree that the aggravating circumstance has been proved beyond a reasonable doubt as to any of counts 4, 5, or 6, you must then answer yes to the special verdict question as to that count. In order to answer no, you must unanimously agree that no is the correct answer as to that count. If after full and fair consideration of the evidence, you are not in agreement as to that answer, then do not fill in the blank for that count. For the aggravating circumstance to apply, a major participant in acts causing the death of Erica, Olivia, or Nathan Anderson, and the aggravating factors must specifically apply to the defendant's actions. The state has the burden of proving this beyond a reasonable doubt. If you have a reasonable doubt whether the defendant was a major participant, you should answer the special verdict no. 31. You will also be given a special verdict form for the crimes of murder in the first degree as charged in counts 1, 2, 3, 4, 5, and 6, and for the lesser crimes of murder in the second degree for counts 1, 2, 3, 4, 5, and 6. If you find the defendant not guilty of each of the crimes of murder in the first degree as charged in counts 1, 2, 3, 4, 5, and 6, and if you find the defendant not guilty of each of the lesser crimes of murder in the second degree for counts 1, 2, 3, 4, 5, and 6, do not use the special verdict form. If you find the defendant guilty of the crime of murder in the first degree for any of the counts 1, 2, 3, 4, 5, and 6, or if you find the defendant guilty of any of the lesser crimes of murder in the second degree for counts 1, 2, 3, 4, 5, and 6, you will then use the special verdict form as to that specific count and fill in the blank with the answer yes or no, according to the decision you reach as to that specific count. In order to answer the special verdict form yes, you must unanimously be satisfied beyond a reasonable doubt that yes is the correct answer to that specific count. If you unanimously agree that the answer to the question is no, you must answer no as to any specific count. If after full and careful consideration of the evidence you are not able to reach a unanimous decision as to the answer regarding any specific count, do not fill in the blank on the special verdict form as to that specific count. 32. For purposes of a special verdict, the state must prove beyond a reasonable doubt that the defendant was armed with a firearm at the time of the commission of the crime in counts 1, 2, 3, 4, 5, and 6. A person is armed with a firearm if, at the time of the commission of the crime, the firearm is easily accessible and readily available for offensive or defensive use. The state must prove beyond a reasonable doubt that there was a connection between the firearm and the defendant or an accomplice. The state must also prove beyond a reasonable doubt that there was a connection between the firearm and the crime. If one participant in a crime is armed with a firearm, all accomplices to that participant are deemed to be so armed, even if only one firearm is involved. A firearm is a weapon or device from which a projectile may be fired by an explosive such as gunpowder. And 33, the presiding jury shall sign the verdict forms as appropriate and notify the bailiff that the jury has concluded its deliberations. The bailiff will bring the jurors into court to declare its verdict. And ladies and gentlemen, that concludes the reading of the jury instructions. If you please give your attention to Mr. O'Toole, who will present closing argument on behalf of the state. Mr. O'Toole?
Thank you, Your Honor. If I might have a moment just to set up.
Sure, go right ahead.
May it please the court. Counsel. Members of the jury, good morning. Members of the jury, I'm going to begin my closing remarks by showing you exactly why we are here this morning, if I might. I'm showing you a photograph of Wayne Anderson. On December 24th, 2007, Wayne Anderson was 60 years old. He was a husband, he was a father, he was a grandfather who worked at Boeing. I'm showing you a picture of Judy Anderson. On December 24th, 2007, Judy Anderson was 61 years old. She was a wife, she was a mother, she was a grandmother. She worked at the post office in Carnation. I'm showing you a photograph of Scott Anderson. On December 24th, 2007, Scott Anderson was 32 years old. He was a husband. He was a son. He was a father. He worked in construction. Scott Anderson made things. I'm showing you a photograph of Erica Anderson. On December 24, 2007, Erica Anderson was 32 years old. She was a mom, she was a daughter, she was a wife, she had 2 small children. Erica Anderson also made things. In December of 2007, she was making a family. Showing you a photograph of Olivia Anderson. On December 24th, 2007, Olivia Anderson was 5 years old. She was the daughter of Scott and Erica, the granddaughter of Wayne and Judy, the big sister of Nathan, and she was in kindergarten. Finally, I'm showing you the photograph of Nathan Anderson. On December 24, 2007, Nathan Anderson was 3 years old. He had turned 3 exactly 2 weeks before, on December 10th, 2007. And on December 24th, on Christmas Eve, 3-year-old Nathan, the son, Scott and Erica, the grandson of Wayne and Judy, the little brother of Olivia, he was still in his diapers. Members of the jury, when I thought about how I would prepare my remarks for you this morning, I was reminded of an old saying from an author by the name of Robert Louis Stevenson. Robert Louis Stevenson once wrote that everybody sooner or later sits down to a banquet of consequences. And I would suggest to you that today is the day that this woman, Michele Anderson, sits down to her banquet of consequences. 5 weeks ago, I stood before you, and I talked to you about a Christmas Eve in December of 2007, more than 8 years ago, when two people, this woman, Michele Anderson, and her boyfriend, Joseph McEnroe, walked out of their mobile home where they were living rent-free, utility-free, cost-free, as a gift from her parents. They walked out of that mobile home, they got into a truck, and they drove up that driveway to her parents' home. Michele Anderson was the driver of that truck. Her boyfriend, Joseph McEnroe, was in the passenger seat. They drove up the driveway, and they parked. They walked up that porch that you've seen in all those photographs, and they walked through that front door. Members of the jury, nobody named Anderson lives in that home anymore. When this woman, and her boyfriend were done, they stayed only a few short hours, but when they were done, a family that had lived in that home for 30 years lay dead. 6 people, 2 grandparents, their son, their daughter-in-law, and their 2 grandchildren. That night that woman, this woman, Michele Anderson, and her boyfriend walked up to the front door of that home, they were well prepared, and they were well armed, and they knew exactly what they were going to do. She, Michele Anderson, carried a 9mm semi-automatic pistol. Joseph McEnroe carried a .357 caliber revolver. But she, in particular, was armed with something else. She was armed with the trust of the people inside and the hatred for the people inside. When Michele Anderson and Joseph McEnroe were done inside that home, they walked out, they got into their truck, and she drove back down that driveway. They returned to their trailer, and they talked about what they would do next. They talked about destroying evidence. They began the process of destroying evidence in that burn pit outside their home. And they planned their next move, which was to flee. When that Christmas Eve began more than 8 years ago, Wayne and Judy and Scott and Erica and Olivia and Nathan were 6 alive human beings whose only misfortune was to be related to this woman, Michele Anderson, and to have befriended her boyfriend, Joseph McEnroe. This trial is, in a very real sense, about those 6 human beings and what Michele Anderson and Joseph McEnroe did to them. It's another old saying that I'm somewhat fond of, and that is that the true measure of a person is what he or she would do believing they would never be caught. Members of the jury, you know such a person. Her name is Michele Anderson. This is a woman who believes she and her boyfriend would never be caught. These were 2 people who chose to operate in the shadows, to operate when their victims were most vulnerable. On Christmas Eve, when they were sitting down preparing for a family dinner, a family that trusted her. This is a woman who believed that she could terrorize those who were close to her precisely because they were close to her. Remember what Mary Victoria Anderson told you when she testified? How her sister had talked about killing her parents? And she was asked on cross-examination, well, did you report that to the police? Remember her statement? Quote, "Who expects a member of your family to slaughter your own family?" Michele Anderson is someone who chose to terrorize people because they were close to her, because they trusted her. They were victims who thought they would be safe inside their own home. Victims who were unarmed and victims who were unsuspecting. Victims who Michele Anderson knew would not be in a position to put up a fight because based on the trust, based on the fact that she was a member of the family, they would never know what hit them. It was from the shadows of that Christmas Eve 8 years ago and her perception of herself as stronger and more powerful that she got her power. Who could stand up to her and Joseph McEnroe, especially when they're armed with a 9mm semi-automatic pistol and a .357 revolver. Who would ever hold them accountable? Members of the jury, we will. Today is the day that the defendant is held accountable, not in the darkness of a Christmas Eve in Carnation 8 years ago, not in a rural home where she can be hidden and no one can see, not where she can terrorize those not as strong as she is. Michele Anderson will be held accountable today under the bright lights of a court of law. Members of the jury, closing argument, as Judge Ramsell indicated, is my opportunity to speak with you about what the evidence in this trial has been. In opening statement, I said to you that I expected the evidence to show the existence of certain facts, and the evidence has done so. But before I review that evidence with you in detail, it's important to keep in mind what is the fundamental issue in this case. And the fundamental issue in this case is simply whether the state has proven beyond a reasonable doubt that the defendant, Michele Anderson, committed the crimes of murder in the first degree, counts 1 through 6. So I'm going to talk to you for a few moments about the law as given to you by the court, a few more moments about the facts as presented in this courtroom. But I'm also going to try to appeal to your judgment, your experience, and most importantly, your common sense. In my experience, it does seem that jurors seem to have an extra sense that lawyers tend to lose once they go to law school. And that extra sense is, maybe, I don't know what you call it, common sense, horse sense. Lawyers sometimes don't get it, but jurors do. And that's why we have a jury system. That's why you are called on to make this very important decision. You have the ability to ask, what is reasonable? What makes sense? So I'm going to talk with you about the law a little bit, about the facts a little bit, and talk to you about what is the only reasonable conclusion one can draw from these facts. And I would suggest to you that that conclusion is that the defendant is guilty far, far, far beyond any reasonable doubt of the crime of aggravated murder in the first degree. Well, how do we know Michele Anderson did this? You've sat through a trial now for 5 weeks, going on 6 weeks. One way of viewing the evidence in this case, one way of sort of organizing or thinking about it, is to do it in the context of the jury instructions. Murder 1 is charged in counts 1, 2, 3, 4, 5, and 6. And it's given to you in the instructions that Judge Ramsell read to you. And rather than reread that instruction to you, I'm going to put a chart up here that simply summarizes what the elements are. Now, as Judge Ramsell has told you, the burden on the state is the burden of proving beyond a reasonable doubt the elements of the crimes. It is a burden that we embrace. And what's interesting is many jurors think that, well, doesn't the state have to prove beyond a reasonable doubt every fact of every case? And people sometimes are surprised to learn, well, that's not the case. In every criminal case, great or small, the burden of proof on the state is to prove the elements of the crime. And what surprises people mostly, I think, in a case as serious as murder, there's only 4 elements. I've summarized them here on this chart. They are given to you at length, as Judge Ramsell read to you, for each of the counts, for each of the 6 victims, in jury instructions 13 through 18. But they say element number 1, that on December 24th, 2007, the defendant acted with the intent to cause the death of, and then for each count, there's a different victim. Wayne Anderson in count 1, Judy Anderson in count 2, Scott Anderson in count 3, Erica Anderson in count 4, Olivia Anderson in count 5, Nathan Anderson in count 6. The second element, that the defendant acted with the intent to cause that death that was premeditated, that each victim died as a result of the defendant's acts. And then the last element, the fourth element, is that these acts occurred inside the state of Washington. Now, there really is no dispute as to element 4, I think. Carnation is clearly, I think, still in the state of Washington. But you may recall that when Detective Tompkins first took the stand, I think way back in January, I asked him a somewhat odd question about the location and the address, and I said, is that in the state of Washington? He smiled, and I smiled, but that's why I asked him, is to simply put on the record formally that Carnation is in the state of Washington, satisfying the fourth element for murder in the first degree. The only real issues here are, is the defendant the person who murdered Wayne, Judy, Scott and Erica, Olivia and Nathan? And the answer to that question, I would suggest to you, is yes, 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 yes. 6 times. And we know that because she did it directly by her own actions, and she did it acting as the accomplice of Joseph McEnroe. One of the other instructions is that you were given is instruction number 9, I think. And it's the accomplice instruction. And it says for you, I've tried to summarize it here, I hope accurately, an accomplice is guilty of a crime committed by another person if he or she is legally accountable for the conduct of that other person. A person is legally accountable for the conduct of another if, with knowledge that it will promote or facilitate the commission of the crime, he or she does any of the following: solicits, commands, encourages, or requests another person to commit the crime. Or any of the following: aids or agrees to aid another person in planning or committing the crime. And the word aid means all assistance, whether given by words, acts, encouragement, support, or presence. A person who is present at the scene and ready to assist by his or her presence is aiding in the commission of the crime. What does that mean? It means that if you're an accomplice, you're held accountable. You're held responsible as the principal. You don't get a break if you're only the accomplice to a crime. But make no mistake, in this case, Michele Anderson is both. She is primarily a principal. She is the reason these crimes happened. These were her idea. This was her family. This was her idea from beginning to end. And in the beginning that began before December 24th, 2007. The victims of these murders were all the objects of her anger. Her anger at her brother, her anger at her parents, her anger at her family. Michele Anderson began the events of December 24th, that murder spree. She's the one who began them in that early afternoon of Christmas Eve. She fired that first shot at Wayne. It missed it, but she's the one who started it. She began the second phase of that murder spree. An hour or so later when Scott and Erica and those 2 little kids showed up, she fired the first shot into the face of her brother Scott using that .357 Magnum revolver. But she's also guilty, not only as a principal, but as I say, as an accomplice. And how do we know that? From all of the evidence that you've received and from her own words when she was interviewed by Detective Tompkins, Detective Peters, and when she made those statements to Detective Cleary. Recall Michele Anderson's statements to Detective Tompkins on December 26, 2007, the day after Christmas, when she and Joseph McEnroe returned to the property. After lying for almost an hour, remember then when Detective Tompkins told you he learned at about 11 o'clock in the morning that 2 people had arrived at the property with some connection to the property. Michele Anderson and Joseph McEnroe. You saw that video where they're walking down the street, walking up the driveway with Troy Chafee, that deputy, and you see the introduction there, and Detective Tompkins is going to make a death notification, try to get some background information, and ask if she'll talk. Remember all of that. They sat down at about 11:08, said Detective Tompkins, and they talked for about 10 minutes. And as they say, he's trying to get some basic background. He's got in the back of his mind, I got to give a death notification to this woman. 6 family members are dead, but I got to talk to her about some background first so I can at least get some information from her. She lied to him then. When he turned on the tape recorder at 11:17, she lied to him then. And it's about 11:57 in the morning, when she'd been talking with him for almost an hour. She lied throughout that entire period before she finally said, it's all my fault. Even though Joseph McEnroe delivered the final gunshot to Erica and to Olivia and Nathan, he did so solely at the behest of Michele Anderson. And why? Because she'd run out of bullets. She had a revolver that held 6 rounds. She told the detective, I fired 4 rounds at my brother. She fired 2 rounds into Erica. And remember what she said, how Erica jumped over the couch and went for the phone? And she remarked, how could she do that? She had 2 bullets in her. That's 6 rounds. Her gun was out. And who stepped forward at her request, at her behest? Joseph McEnroe. Just as he did earlier when she fired that 9mm that missed her father, but her gun jammed. At a very minimum, Michele Anderson played a supporting role. The reality is she was the principal. She is the reason why this happened. It was her hatred of her family. We know this, not only did she assist, she took that lead role. As I say, she, not Joseph McEnroe, fired that first shot. She, not Joseph McEnroe, fired that first shot when Scott and Erica and the children arrived. She, not Joseph McEnroe, fired the first shot that hit Erica. She, not Joseph McEnroe, probably fired the first shot that hit Olivia in the abdomen and went through her body. She, and not Joseph McEnroe, fired the last shot, the coup de grace, into Scott Anderson's belly as he lay, dying on the floor, inches from his wife and children. The truth is that Michele Anderson did much, much more than assist in these murders. She is the reason that this slaughter occurred. These murders would not have happened but for Michele Anderson. And how do we know this? It comes again from the evidence. All of the evidence, direct evidence and circumstantial. As you can imagine, I have a chart here on direct and circumstantial evidence. This is from jury instruction number 5. And that tells you what evidence is in a case. Criminal case, civil case, great or small, it's the same. Evidence may be either direct or circumstantial. Direct evidence is evidence given by a witness who has directly perceived something at issue, and circumstantial evidence is evidence from which, based on common sense and experience, you reasonably infer something else, something that is at issue. In other words, direct evidence is a witness that gets on the stand and tells you what he or she saw, or heard, or tasted, or felt, or smelled. I saw it, here's what I saw. That's direct evidence. Circumstantial evidence is a little bit different. It's evidence based upon common sense and experience, allow you to know one thing and to determine something else is also must be true. This is a tribute to a lawyer's ability to write these jury instructions. I think it's pretty evident if you can make decisions, you can make conclusions based on circumstantial evidence. So why do I tell you this? Because if you watch enough TV or movies or read enough books, John Grisham or whatever, people are always saying, hey, it's circumstantial evidence. I can't convict somebody on circumstantial evidence. That's not good evidence somehow. That's a myth. That's a myth of the books, of the media, of television, and the movies. The law says to you very clearly that one is not necessarily more valuable than the other. You may decide it. You decide it. The judge doesn't decide it. I don't. Ms. Anderson's counsel do not decide what is more important. You guys do. And you may decide that the circumstantial evidence is more compelling than the direct evidence. Or direct is more compelling than circumstantial, or they're equal. What's probably the most significant example of circumstantial evidence and how it can be compelling? DNA. DNA doesn't tell you why. DNA tells you what or who was present. Someone's DNA at a scene is circumstantial evidence that they were there, even though no eyewitness ever saw them there. And that's an example of the power of circumstantial evidence. So don't be in any way sort of misled by the common misconception that circumstantial evidence is not valuable. It can be very, very valuable. And probably one of the best ways to, I always think about this, to try to describe it is a story that was written a long time ago. It was not when I was a little kid, but I read it when I was a little kid, called Robinson Crusoe. And if those who have read the story and remember it, Robinson Crusoe, stranded on a desert island, very, very despondent, very depressed, very down, because he's alone on the island. And it looks like he's going to be alone on the island for the rest of his life. There's really no hope of rescue. Until one day, Robinson Crusoe walks along the sand, and he looks down and he sees a footprint in the sand that he did not make. That was circumstantial evidence that he was not alone, that there was somebody else on that island. And guess what? He was right. Friday was on that island.